Good afternoon. I will call the Legislative Commission on Data Practices to order. Welcome to everyone in the room. The first order of business would be approval of the minutes from September 19th. We don't have a quorum, do we? There's Senator number 1, 2, 3, 4. We've got 5 people. We got 5 of us. Is that a quorum? Okay. We do have a quorum. Any discussion on the minutes? Okay. I don't know if I moved them or not, but I'll move them. And all those in favor of approval of the minutes from September 19th, please signify by saying aye. Aye. Opposed, same sign. Minutes are approved. The first order of business today is House File 1507, and then, so we'll hear a summary of 1507, and then we'll hear a summary of Senate File 1980 with Senator Kent, and then we'll hear public testimony after that. So, Representative Lucero.
Thank you, Madam Chair.
Anytime you're ready, go ahead.
Well, thank you, Madam Chair, and members of the commission, and quite a large audience. This is great. So this is a very important topic, student data privacy. Several members of the commission have been on committees in the past. Actually, there's some people missing here, so I guess my statement is not true. So none of you have actually heard my PowerPoint presentation except for the chair. So what I was going to do is dispense with the PowerPoint presentation that I had given in at least 2 committees in the past and just give some points from that PowerPoint. So starting out in terms of background, right now the Education and Technology is Chapter 125B. In Minnesota statutes, and it's 5 pages in length. It dates back to 1980, and it includes contracts for computers and equipment in schools, and that section has not been updated since approximately 2000. MDE is part of this 5 pages, and it's MDE department duties, and that's not been updated since 2003. Internet access for students section, not updated since 2007, with the exception of a charter school definition pointer, and that was in 2015. So the point is, the statutes themselves go back more than 30 years with relatively little updates. But during that same period of time, 30 plus years, there have been tremendous changes in technology and the capabilities and the incorporation of that technology within the K through 12 and the higher ed, but for our purposes, K through 12 educational experience. And they have been very beneficial. It allows our students to have multiple educational opportunities that they might not otherwise have. But along with those capabilities that have increased, as I've demonstrated, there have not been a corresponding updating of the statutes. And that's what brings us here today, to have that conversation, a continuation of a conversation that was started a couple years back that has been a bipartisan conversation, and I'm very proud of that, because the topic of student data privacy is not partisan at all. It's one that each and every one of us is important. It's important to us and a priority to ensure the protection of the data of our students. So when it comes to student data privacy, there are 2 types of data breaches. Most often, when it comes to computers and systems, when we see the headlines of computer breaches, the most common one is the one where somebody has gained access to information that they don't or are not authorized to have access to. But there's another type of data breach that's less publicized, and that is those that do have authorized access to data viewing information and doing stuff with the information that's not authorized. And both types are extremely important to be cognizant of. As the years have gone on, we've seen multiple data breach headlines, both from private sector, but from the government sector as well. There have been multiple breaches, and then this year alone, we've had a couple, the Washington schools, and there's been several that cause much consternation for parents. So the solution is, and the intent of this bill is to protect student private data and ensure parental authority over their children's private data. Now, being that I am from the technology industry, I've been in the cybersecurity industry for 15 years approximately, there have been tremendous amounts of changes as societal attitudes have changed over the requirements to protect data. And I would say most of that, the catalyst for changes in our industry, in the technology industry, came about as a result of the Enron scandal for the most part, and Sarbanes-Oxley. So SOX was, it's a regulatory compliance mandate that was introduced that placed mandates on US-based publicly traded companies. And during that time, or when that was first, these mandates were being discussed and eventually rolled out, the conversation and the pushback from the industry was, and I say the industry I'm referring to is the pushback is from any businesses that would fall in scope of that US-based publicly traded that would then have to change the way that they do things and or spend money to ensure greater protections. And the pushback was, it's going to cost us, excuse me, costs more money to ensure greater protections. And that is a very true statement. But changing processes, incorporating in handling procedures is what society expected. So there are growing pains, no doubt, but there are changes that, as we've heard people and pushing back, they've had to come to terms to understand that there are requirements and are expectations that need to be met. And that requires an adaptation and updating of the handling procedures and the way that things have been done for the last several decades. And I'm receiving similar feedback in regards to 1507, similar comments, but again, it's something that isn't new. And Sarbanes-Oxley was the first, but Graham-Leach-Bliley Act, a GLBA, HIPAA and high tech, and then the payment card industry, PCI, in regards to credit cards. So there's been a wide adoption and a wide recognition of the need to make the updates. So that's the reason we're here, and it will require educational institutions and different stakeholders to change their handling procedures and the way that they may be doing things, but it is for the better in the end, for everybody. So the intent of our bill, it's to increase efficiencies, increase educational and career opportunities, while at the same time decreasing costs and allowing the use of de-identified data for very valid educational purposes, but requiring opt-ins for the transfer, sharing, and accessing of PII by third parties, with the exception of directory information and a few other exceptions that we want to discuss, and then put controls in place to better ensure protection and mitigation against risk and threats to student PII. So as we've been having conversations here with multiple stakeholders, we are getting great feedback. Because when we put 1507 out, that's a starting point for discussion. We have to start somewhere. And we've met with multiple stakeholders, Minnesota Association of School Administrators, Minnesota High Tech Association, Minnesota Private College Council, Minnesota School Boards Association, and many others, just to name a few. But they are giving us great feedback. So with that, Madam Chair, I think I'll turn it over to testifiers here to do a brief walkthrough then of 1507.
Okay. And so, folks in the audience, what we're going to do is go through each bill, and since these folks have background in the bill, we'll go ahead and let them address it, and then we'll take all public testimony after both bills have been heard. So, Senator Kent, if you have other people that you would like to have sit with you that are experts on your bill, or anyone that could help supplement, you can do that too. So, all right, go ahead. Please state your name for the record.
Madam Chair, members of the Commission, my name is Ben Feist. I'm the Legislative Director for the ACLU of Minnesota. And since I've been involved in this bill for a while now, I was asked to sort of break it down into digestible pieces for purposes of the commission today. And as I do that, I want to really take a big step back and explain the two types of technologies that this is really directed at. It used to be two separate bills, one on the student, the SIS, Student Information Systems concept, and then the other on one-to-one programs. And so I'll talk about those for a minute before we even jump into what the bill actually says, because I think it's important to have some context. Back throughout the history of our schools, we've expected a lot of this personal data that has to be collected by schools to stay in a filing cabinet in the principal's office. Disciplinary records and all this very personal stuff that's essential for the school to run. And we don't want to mess with that in any way, but what we have to accept is that now these systems are online cloud-based things that the districts contract with. And I'd like to take a step back to say, as a kind of analog version of this, imagine a student information system is like a security deposit box at a bank. And what you're asking is for that data to be stored so it can be used. And you have a relationship with your bank, let's say to put in your jewelry and valuables. But you don't have an expectation that the bank has a right to then go into your box, take out your jewelry, wear it around town, right? Our expectation is that it's going to stay there, it's going to stay secure, and it's really for your value. In this case, the value of this for the school is just being able to have all of this data in digital format and be able to use it. And so I think that's an important way to sort of conceptualize what is happening in these relationships with the SIS providers. That's what we're talking about, and what we're limiting in this bill is the ability of the SIS, not the schools, but of the SIS themselves, to analyze, manipulate, sell, or do other stuff with the data that's being held on behalf of the school and on behalf of the students. The other part of the bill is relating to these one-to-one programs. And when we say that's just the shorthand to describe when a district works with a company to provide usually free laptops or iPads to all the students in the district so they can use that technology. The issue that we're trying to deal with in that section is that as part of that transaction, you often have a situation where data is being collected on that device, and whose data is that? Does that belong to the school to do whatever they wish with it? Does it belong to the student or to the company that provides that device? And so this really goes in there to say that all the personal information, the websites that you're browsing, the keystrokes you're entering, your location, because a lot of them are GPS enabled, will all be still the student's private information. And if the school or the provider of that device wants to do anything with that data, they simply need to get an opt-in affirmatively from the parents of the kids saying that they want to use the data for a different reason. So with that overview, I'll jump in here. We have 4 pages first of definitions because there's a lot of new concepts, many of which I've been talking about right now, that we don't get to just cross-reference in other parts of the law, since this is pretty new, at least in the school context. Once we get to Section 4, Student Information Systems, Subdivision 1 pertains to the contracts that between schools and providers. And this has some really simple provisions for what we expect would be in a contract between an SIS provider and a school today, but there's no statewide system mandating what that should look like. So here we're simply saying you need to require security measures to protect this personal information. You need to affirm that the data stored there is the property of the school, not the provider. Require policies and procedures for dealing with data breaches, data retention and deletion policies, prohibitions on sharing, transferring, or analyzing data unless there's an opt-in, prohibitions on selling student data, on using it for marketing, advertising without an opt-in, again, and prohibitions on using the data to develop a profile of a student or group of students for commercial or non-educational purposes. So there could be educational purposes that are still certainly allowed in those contracts. Subdivision 2 goes to this opt-in agreement. And again, I want to be really clear, the opt-in is not something that the school has to get. This is something that the SIS provider who wants to do something else with that data would have to get directly from the parents if they wanted to do something. So it's on them. It's not on the schools. We've heard some concerns that schools would be in a position where they would be forced to get every single student to opt in before they can send disciplinary records to the Department of Education. And under this bill, that's simply not the case. That operation of sending disciplinary records, for example, will always be the requirement on the district, and they can be the ones using the data and sending it, even if it's through an SIS. I assume that's not something that they would delegate out to a third party to actually be the one to do that task anyway. So when we're talking about opt-ins, it's really all about what an SIS needs if it wants to do something else that's not part of the contract as provided above.
Mr. Feist, if I could
Yes.
stop you right there, put a placeholder there in the conversation. When I was looking over the bill again last night, fresh on my mind was the fact that I'd gotten an update request on my phone. And so I started actually reading, like, what was contained in that, instead of just saying, yeah, I accept, I agree. And I don't agree with all of it. There are parts of it are fine, but there are some privacy provisions in there that I didn't agree with. So an opt-in agreement, when it comes to this, I think would have to be worded in such a way that, yes, I agree to this, or no, I don't agree to this specific section of whatever is sent out to the parents. So is that, Representative Lucero, is that something that you had in mind when you were referring to the opt-in in your bill?
Thank you, Madam Chair. And no, that's a great point. Having something rather than an all or nothing proposition. That's exactly what the intent of the bill is to empower parents. And we don't want to be in a position where parents are prevented. Perhaps they want student information to be shared, transferred, sold, etc. We want to empower parents because they are in the best position, rather than the assumption of it's automatically allowed. So yes, allowing that granularity would be the intent of the bill, absolutely.
Okay, great, thank you. Go ahead.
Thank you, Madam Chair. So the subdivision 2, I think, kind of goes to your point. Subdivision 2 here says that a valid opt-in agreement must include a handful of things. It must identify the data that the SIS wants to use, must identify the SIS provider and what they are authorized to do with that data, must identify educational purpose, must identify the individual student subject to the opt-in, must include authorization to share or transfer educational data, or may include authorization, to share or transfer educational data. So that's something that is still possible under an opt-in. That a parent or guardian may revoke it. The educational institution must not withhold an educational benefit from someone or penalize you if you don't opt in to the SIS or with the SIS, and it must be renewed annually. So there are sort of minimum qualifications of what we think any opt-in should look like, but that could be tailored to whatever the specific need is or the ask is of the SIS in that case. And I don't think we would imagine that it would be a universal, all this data is available for anything. It would have to get a little specific there. Subdivision 3 then pertains to school employees, and this says that school employees may access and interact with educational data on an SIS to perform their professional duties and requires some periodic training in how that works. You may transfer the data for record keeping and management purposes on there if you're a school employee as well. Subdivision 4 pertains to parent access and includes a limited right to review the data on an SIS to make sure that that is all above board and what they'd expect to see.
Mr. Feist,
Yes.
do you not think under current law that the parents already have the right to access that information? Under 1332, and actually 1302, sub 8 or 11 or something like that, that the data subjects have the right to access the information. If they're a minor child, their parents have access unless they think that that access would in some way endanger the child. So do you think that's already current law?
Madam Chair, I believe so. I believe that would be covered. I think we just really wanted a belt and suspenders approach here and to be really clear within the context of setting up this new system. I mean, yeah, again, whether that ultimately would need to stay in there or whether it's covered somewhere else, I'm not sure. But
Okay.
I'd like to think that that is already the case.
All right, go ahead.
So moving on, subdivision 5 deals with requirements on an educational institution to delete certain data after a student graduates, withdraws, or is expelled. Subdivision 6 pertains to requirements on the SIS to delete copies of that same data after one of those things happen. Subdivision 7 requires notice by educational institutions to the SIS and other third parties after graduation. Subdivision 8 states that only the school or SIS shall have access to that data unless authorized by law under a warrant or as part of an educational institution audit. Subdivision 9 is where we say that directory information is permitted, so there should be no question here that this bill doesn't change anything with how directory information is currently treated. And then finally, subdivision 10 deals with the interaction with other law. As we've said, Chapter 13 still applies, and other privacy protections are, as long as they go above and beyond, would be consistent with this bill. So that's all the SIS section really is. It's long, but I think pretty straightforward when you look at it this way. Section 5 of the bill is about these one-to-one programs. And this starts with the general rule that when a school and provider contract for one-to-one services, no school employee, provider, or an agent thereof should be able to track the student's activity on that device, the data, and do so remotely or in person, unless exceptions apply. And this whole chunk of the bill is really full of exceptions. This part also says that any contract must affirm that the data on the device are the property of the student and school and not the provider, provides notice, and prohibits the sale, sharing, or use of the personally identified information. Subdivision 2 gets to these exceptions because we understand that there are a lot of times where we can't leave all of the control in the hands of the student. So, for example, may access and use data if it's de-identified or aggregate data. School employee accessing the data can be a teacher using for legitimate purposes. If the school employee or provider gets an opt-in, again, that can be used for different things. If a school employee reasonably suspects the student violated or is violating a law or school rule, and the data on the device contains evidence of a suspected violation, subject to some limitations, that's still permitted. School employee or law enforcement official reasonably suspects the student's engaged in or has engaged in illegal conduct, reasonably suspects data on the device contains evidence of the conduct and secures a warrant. So that's another piece here. If there's a need to upgrade the software, protect it from cyber threats, and access is limited to that purpose, it's another time that you can get access. If it's needed to respond to an imminent threat to life or safety, and access is limited to that purpose.
Mr. Feist?
Yes.
I have a question on 11.20 and really the rest of kind of that page where it's talking about searching a student's device.
Yes.
And the reasonable suspicion that's required in 1121, would a search warrant be required there, a court order? or kind of walk me through what you think the procedure would look like to search a student's device.
Sure. Let me just take a moment here, Madam Chair. Yeah, so I think on 1120, as you mentioned, that's the first instance that we're talking about it here. And this understands there may be situations where you would want to search a one-to-one device, and the reasonable suspicion is, I think, just a standard that the school would have to look at. This isn't necessarily the same reasonable suspicion that law enforcement would need in that case. But if you have this suspicion and you need to check the device for evidence of a violation, then you can seize it. And to do so, you'd need to give some notification of the seizure, it looks like, and make sure that it's basically kept as evidence that the search can happen, but it has to be limited to finding evidence of a suspected violation. So I think the idea behind this procedure is understanding that there could certainly be situations where you would need to do this, but there's a lot of data on a device that even if there's a suspicion that there's something going on at the school or otherwise, you don't necessarily need the school officials or even law enforcement looking at all of that data, having full access to everything that's on there. So I think the idea is simply to limit as much as possible to what you really need, what type of evidence there might be of a suspected wrongdoing in some way. And I think that's the way it's, at least in that section, set out. I think we have some other pieces as well.
If I can just, Madam Chair, and if I could just add one piece. When it comes to law enforcement, and in the context of warrants, there is a requirement to articulate the places to be searched and the items to be seized, to clearly articulate what that is. So what's happening here in line 11.20, before searching a student's one-to-one device, a school employee must document the basis for the reasonable suspicion. In other words, it's placing a burden that it's not arbitrary. It's the ability to articulate and document what the reasoning was for going into a student's technology system.
And so, if I might ask Representative Lesh if he might know the answer to this question as a former prosecutor. So, right now, if first of all, I think that the language probably needs to delineate whether this is just a violation of the school policy or if it's a violation of the law. So, if it's a violation of the law right now, do you need a search warrant to confiscate somebody's electronic device? And keep in mind, in this case, they're a minor.
Madam Chair, remember that the only time that a search warrant matters is if you're looking to apply criminal charges. So if you take someone's data and there's not necessarily any intent to pursue criminal charges, the only implications for that could be some kind of civil damages. So the violation of a student's privacy rights under the Fourth Amendment could preclude you from bringing those charges because of the evidence would be fruit of the poisonous tree being an illegal search. So it really depends on your motives for taking them, and I think you probably would be skating on thin ice criminally without a warrant because there is an expectation of privacy, I think, but this is a new area of law. But without that, it depends on what kind of damages you can prove you suffered for it, and that's, I mean, good luck on that. That's my answer.
Thank you. Representative Schultz?
Thank you. So who owns the device? If the student doesn't own the device, can't they say that if the school owns it, can't they take it without worrying about getting a warrant? I know it, for employers, they can search their employees' computers because they own the device. So who owns the device?
And I think that may vary a lot of times Apple or some third party will supply the device to the school. I don't know how many, and when we get to testimony, some of the schools can kind of tell us what they do, if they own the devices or not. But Mr. Feist, did you want to take a stab at answering that question?
Well, Madam Chair, yes, I think this is actually one of the issues that we are trying to get at in the bill a little bit here, because the analogy has been made to the locker rule in schools, that students don't have an expectation of privacy in their locker because it's essentially property of the school. And so that's a very, again, kind of classic old technology analog way of looking at the world from my perspective. The laptop or the iPad that's given, while it may still be school property, goes home at night. It doesn't stay in the school building. It contains lots and lots of personal data that would not be in a locker, for example. There's not going to be direct contraband in or on a device like there might be in a locker. So I think where the law is at right now is sort of at a crossroads and trying to figure out how to deal with new technologies and the ownership of not just the device, but the data on the device. Just because the device itself is owned by the school, isn't there some ownership of a student's personal information and their comings and goings, their location, the sites that they've been on? So we are trying to kind of establish a new baseline for that so everybody understands what the expectations are.
Madam Chair.
Representative Lucero.
Thank you, Madam Chair. And Representative Schultz, that's just to piggyback on what was being mentioned here. There's really three scenarios. It's the scenario where the device is personally owned, where it's personal private property, bringing in a laptop, bringing in a mobile device. The scenario where it's school property and it's being used by students. And then the third scenario would be it's neither of those, and it's the vendor device that's been provided by Apple or Microsoft. So it's neither the students nor the schools. In any of those cases, using the locker is a container. So think of the device as a container, whereas the locker contains tangible items, the digital device contains digital items. Both of those can be private property. So what limitations currently exist for a locker, that container? The school, my understanding is, has some authority to go into the locker, but their authority ends when it goes into the physical items of personal ownership. Does the school have the right to look into the backpacks, the personal private property? So again, there's going to be boundaries there. So taking the concepts that are well established, decades old, when it comes to the physical realm, lockers as an analogy, the same principles apply then when the repository, the container, is in the digital realm. Because there's personal private information that belongs to the individual, while it might be inside of a container that's the schools or providers.
Follow up, Representative?
So the intent of the bill is to require a warrant in all three of those scenarios?
No.
Representative Lucero. You want to elaborate on that? 'Cause
The intent of the bill is to make it clear that the school does not have authority if it's a personal item, except in the cases, I think, of an exigent circumstance or a threat to harm. But again, those processes, it's well-established precedent in the physical realm. When an exigent circumstance exists that allows for a bypassing of the legal process in the physical realm, the same would be true in this realm. What it attempts to establish is a process in different scenarios and creating the understanding that there are different scenarios exist, and where different scenarios exist, there would be different processes, but again, allowing for exceptions of exigent circumstance threats because we need to allow for those exceptions.
Thank you. Okay, go ahead.
All right. So looking now at subdivision 3, I believe. It's the section on location tracking technology on the device. And one of the important pieces here is that all these are GPS enabled these days, and I think it's very important for a school to be able to know if a device is lost or stolen, where that's ended up. But as we've dealt with in data practices issues over the last several years, especially in the law enforcement realm, we have more and more questions about the ways that we can be tracked, where our cell phone can be tracked, where our cars can be tracked, these sorts of things. And once again, we have another device here, government issued, that can have real-time and historical location tracking enabled. So in those cases, if you want to get that information, there is a warrant requirement unless it's reported missing or stolen, or getting access to the location is necessary to respond to a threat to life or safety. So with some big exceptions, again, the idea is that just like in Minnesota, we now, after a couple of years ago, have a law saying that you need to get a tracking warrant to track the location of your cell phone. The same thing would apply to a student's iPad. So you can't just find out they're over at Jimmy's house unless there's a really good reason to know that. Subdivision 4.
Hold on one second.
Oh, sure.
Madam Chair?
Representative Lucero.
Thank you, Madam Chair. And I would just want to also point out that in regards to location tracking capabilities, that's a very hot button issue. And it doesn't matter what the context is. Madam Chair, you and I earlier this year were part of a conference, and one of the presenters of that conference was the automobile manufacturers giving results of a study that they had performed. And among the most sensitive topics that creates concern to the general population is location tracking, and how automobile manufacturers have that capability with GPS in the car and stuff like that. But it doesn't matter what the context, whether it be automobile, whether it be a cell phone, whether it be education, whether it be law enforcement. There has been multiple, recent bills and topics that have come through this legislature. It's a very hot button issue. It's one that people are very concerned about. People don't want to be tracked. And if they are tracked, they need to be made aware of it. And there has to be controls around that. So that's added points to why this is very important.
Thank you. Go ahead, Mr. Feist.
Madam Chair, subdivision 4 pertains to remote viewing of what's on the camera of the device. There have been a couple scary instances in other parts of the country where one of these devices that was sent home was activated remotely and got some video of kids in their homes in various activities. Obviously, that would be a very scary thing. We hope never to happen here in Minnesota. So this simply says that no school or provider may activate audio or video on a device unless the student initiates a chat, there's a warrant, or again, responding to an imminent threat. Subdivision 5 pertains to student password protected information, and basically says that no school employee may view password protected software, website accounts, or apps unless the employee is a teacher, the student is enrolled and participating in a class with that teacher, and viewing the device serves an educational purpose. So that's really going to the fact that you might have a Facebook account or something like that that you access via that device, and just because that is in the realm of being there, that the school employee may demand to see it because it's on a school device.
Representative Schultz.
Thank you. So it says applications. Are these all password protected websites, password protected applications, or just applications?
Madam Chair and Representative, yes, that's the idea. This would all be password protected. So only those where you have to have a single login account that's not issued by the school.
Okay, that doesn't, I think we need to make that more clear in the bill language. Because I could envision a volunteer in the classroom who's not a teacher wanting to do a reading app with the child to develop their reading skills. And they would not be allowed to do that if the bill language is currently in its present state.
Okay.
Madam Chair.
Representative Lucero.
Thank you, Madam Chair. The spirit behind this section is, and I'll just read 13.17 and 18. No school employee or their agent may use a one-to-one device or require a student to use a one-to-one device in their presence to view a student's password-protected software, et cetera, et cetera. The spirit is, it's trying to prevent school employees from compelling students to turn over their password or to log in their presence. So as we all know, Facebook, just as the example that was used here, Facebook is username as a credential set, password is required. And if Facebook is accessed on a one-to-one device, can the school compel the student to log in front of the teacher, whereby now the teacher has access to a private account that just so happens to be accessed through a school device? That's what this is getting after.
Right, and I think Representative Schultz, if you read numbers 1, 2, and 3 below that on 1320 and following, it talks about the exceptions. So the exceptions are when the school employee is a teacher, the student is enrolled in and participating in a class taught by the teacher, and viewing of the one-to-one device serves as an educational purpose. So if there is a reading program that they're using and it is password protected, then the circumstances change.
But that's only if you're a teacher. We have a lot of
Oh, if you're volunteer.
volunteers
Okay.
that they would be not allowed to work with students on that reading app.
Okay.
To develop those reading skills.
All right, okay.
I'm trying, look, where's the definition of teacher? Madam Chair?
Yes, Representative Lucero?
So turning back to the definition, section 3.19, there's a definition of school employee. And Representative Schultz may have found a good example where the word teacher is not defined in the definition section. And the word teacher in, which line was that, 1320, could be replaced by the definition of school employee.
But volunteers are not school employees.
Right, volunteers aren't school employees, so she's right.
Madam Chair, while the word school employee may be used, maybe school staff, even if the word school employee were the word, we could include in the definitions a volunteer.
All right, go ahead. Get towards the end, I think.
Yes, Madam Chair, thank you. Moving right along, subdivision 6 prohibits a provider from using educational data stored on a device to market or advertise unless there's an opt-in. So here's where opt-ins come into play for the one-to-one, that we acknowledge that we're not going to say you may never market or advertise, but there definitely needs to be the parental opt-in if we're going to allow that. They also are prohibited from developing student profiles for commercial or other non-educational purposes. Subdivision 7 requires training for school employees on using one-to-one programs. Subdivision 8 states there's no sharing of educational data from a one-to-one device except to another trained school employee for professional duties or where the provider is authorized under an opt-in. Subdivision 9 lays out opt-in, what the opt-in agreement should look like. Again, I won't go through all that in detail because it's very similar to the sort of opt-in that you'd expect for the SIS.
Representative Schultz?
Thank you. On the opt-in agreements, who provides the oversight, the accountability on these organizations that provide the devices so we can assure that they're not collecting data on those that opt out?
Very good question. Representative Lucero?
Madam Chair, well, presently, the status quo is nobody. So any change in the direction of having greater control would be better than the status quo. And so one of the things, and I'm not sure where it is offhand, but one of the concepts that we definitely want to have in here is an audit. An audit to ensure that standards, or processes, standards, and procedures are being followed. Because it's important that there's accountability and that there is review to ensure that things are being adhered to, so.
And this would be an audit by the legislative auditor or?
Representative Lucero?
Madam Chair, so one of the things that the beauty of the technology is that it's all the same for the most part. It doesn't matter who's using it. Windows systems, Unix systems, laptops, mobile devices, it's all the same technology. So the procedures and the requirements are commonly shared across the board no matter who's using it, no matter what industry they're in. And so one of the beauties that we have within the IT security is that there are companies out there that perform audits. So take Sarbanes-Oxley, for example. There are companies out there that will have a third-party independent come in, audit the company to ensure that they're following and adhering to Sarbanes-Oxley. Then that third-party company would publish a report that then the company that was audited can make available to any customers that they might want. Same thing for HIPAA High-Tech, same thing for PCI compliance, and right on down, so on and so forth. So that the audit could be any third party who's qualified to perform the audits to ensure that it's independently reviewed and are being followed.
So is the state, the school districts are not liable if they fail in that audit review, if they're not following the procedures and standards set in this bill? Is the state at all liable for that if a family information is shared?
Madam Chair, right now there is almost nothing in state statute for that. And I would go, I think it was this commission, or was it might have been the Education Policy Committee 2 or 3 years ago. I forget where it was now. But there was a review, and we had the department up here, and it's a common practice with any technology system. To the data contained within the technology system, could be PHI, PI, it doesn't matter what it is, to be shared with third parties. And when in the private industry, there's contractual language that's typically negotiated and put in place that if and when data is going to be shared with a third party, that the receiving party have mechanisms in place, controls in place that are equal to or greater than the controls that are in place to protect the data from the source. Right? So when we were speaking with the department then, they share information, our students' private data, approximately 30 to 40 times per year with third parties. And then I asked the question, are you performing any kind of audit or any process to ensure that the destination parties with whom information is being shared, these third parties, that their technology systems have controls that are equal to or greater than the department's? And the answer was no. So how long have you not been auditing? It was at least 10 years. So our students' private data, 30 to 40 per year for at least a decade, has been transferred out without a mechanism to ensure that controls are in place that are equal to or greater than. Now, so the question becomes, under the scenario, what if there's the department shares students' private data to a third party, and that vendor, that company, whoever it might be, could be a research institution, who knows who it is, and they take part of that information, it's stored on a laptop that doesn't have hard drive encryption. And then that laptop is left in the back of an SUV without a trunk, or it's in a trunk that gets stolen. Now all of a sudden you have private information on a laptop that's not encrypted, that's been stolen, and there's no mechanism to inform the department, let alone the school district, let alone the student or parent, that their information has just now been potentially compromised. So who's accountable to your question? There's very little right now.
But have there been,
Representative Schultz.
thank you, Chair. Have there been other cases in other states where the states have been liable for data breaches with student data?
Representative Lucero.
I am not prepared to answer that question right offhand.
And I don't know, Representative Lucero, looking through this bill, I'm not seeing audit trail language or anything in here, so I know I'm receiving reports right now as Chair of the Civil Law and Data Practices Committee on body camera. That was part of the law that was passed, that they had to create audit trails and have it audited. And so I'm starting to receive some of those reports right now. So I agree with Representative Schultz. If we're going to do a bill, we're going to put in place new law, then let's make sure that there's some accountability.
Madam Chair, I appreciate those comments, and that's exactly right. And one of the things I didn't mention up front here at my opening comments was, among the different stakeholders that we've received great feedback from, there has been recognition, obviously, of some gaps, things that need to be changed, and we have amendment language that we're preparing to incorporate, but we didn't want to put that out now because there just wouldn't have been enough time for the stakeholders to incorporate that in and be prepared. So we wanted to have the conversation as is. But there will be amendments, and one of those you identify, I recognize that as well, that there isn't audit language in here, but that would be an intent.
All right. Go ahead and finish. Oh, wait. Oh, sorry, Senator Kent.
Thank you, Madam Chair. And you really hit on the point that I was going to make, which was I wasn't seeing the audit language either. And you're exactly right, Madam Chair. You know, that is, I think, an important development that we've been introducing in various areas. And I think it makes sense to do so here, but it needs to be spelled out. And it needs to be spelled out as to who would be accountable. The department, the districts, however that's going to be, but it needs to be delineated. One thing I would say is, having worked on the Education Policy Committee, I know the Department of Education is struggling from an IT standpoint, and so we would need to make sure, and I know that we have one of their representatives here, I don't know if he'd want to testify later, but to make sure that they have the resources that they need to actually be able to deliver that, because I know in some agencies that's been one of the challenges. The existing infrastructure that they have just can't handle those kinds of tracking capabilities, which I think is a smart idea. Which brings me, if I may, one more question on a similar note. On page 13 under subdivision 7, where you're requiring training, annual training. When this bill was introduced, I don't know, did you do a fiscal note or fiscal impact? Because I would imagine that would be a pretty significant, when we do annual trainings in schools, there are a lot of people that would need that. And how's that going to be funded would be my question.
Representative Lucero or a testifier, if you want to phone a friend.
Did you?
Go ahead and introduce
Hi, Madam
yourself.
Chair. Kirsten Schultz. The FERPA training is provided by the U.S. government. They have a section of the government that provides that either on paper or through webinars for schools.
And Madam
Senator
Chair,
Kent.
and to the testifier, so would that FERPA training, we would need to make sure that according to this language, that FERPA training would be applicable and would address what's being required here in statute.
Ms. Schultz.
Madam Chair, that is correct.
Thank you.
Madam Chair? Can I?
Representative Lucero.
Thank you, Madam Chair. And I just want to, Senator Kent there, yeah, you bring up some good points, and the thing I would say as well is it's not the Department of Ed is not unique in struggling with the technology systems. It's government, all the agencies are struggling with their technology systems because the law is not keeping up with technology. And I've experienced this firsthand. We're great people down here at the legislature. We're great. Staff is great, but eyes glaze over really quickly when I try to have conversations about the need to fund some of this stuff and why it's important. And so they're not unique, and I don't want to pick on them. We need to do a really good job here at the legislature recognizing the shifting attitudes of residents of Minnesota and the requirements that they're placing not only on private companies to ensure protections and controls are in place for the private data, but also government.
Thank you. Representative Schultz.
Thank you. Is the intent to have annual training for every person every year, even though there may be no change in FERPA? Or is the intent is to make sure that people are working in this environment have been trained and they only need retraining if there's a substantial change in FERPA?
Representative Lucero or your testifier.
Madam Chair and Representative Schultz, the intent is to have, so first of all, it'd be those in scope would be those school employees or staff that are handling data. And so the intent is to ensure that people are properly trained to understand the importance of data handling in a secure manner. And then to do it on an annual basis, yes, but there are multiple means by which training can take place. It doesn't have to be a person in front of a classroom and, cycling employees through, classrooms like that. It can be online, web-based. It can be, I know that there's all kinds of teacher conferences that take place with breakout sessions. There's multiple opportunities to go through data handling procedures and training.
And I think too, when we're going to have testimony from some of the schools here, and let's ask them those questions. Are they doing that annually now? And is it the same thing for every year?
I mean, I wouldn't want to make it redundant. I mean, I would want to not have them go through a webinar every year if there's no changes. Unless you want that, unless that's your intent, is to refresh their memory.
I think, isn't FERPA, isn't the federal law, is it an annual thing, or does it just say periodic? Anybody know? Staff, anybody?
Yeah.
Ms. Schultz?
Representative, are you talking about in this bill?
Well, the required FERPA training, isn't there required federal FERPA training too, or not?
There is
No,
not.
there's not, okay.
No.
All right.
The Department of Ed has run some classes across the state.
Okay.
But we went to that class 2 years ago, and there were only 17 people in that class.
Okay,
So-
all right, very good.
And then, Madam Chair,
Representative,
I would also just mention one thing to Representative Schultz, that, so as a real estate agent, I have to go through continuing ed, and I need to do 30 hours every, let's see, it's either 15 or 30, I forget offhand. 15, I think it's 30 hours every 2 years, every 2-year cycle. And one of those is fair housing. I've had to go through the same fair housing every single year, learning the same thing on how all people are allowed by law not to be discriminated against, right? And it's a continual refresher and reminder, and it's an important one. And when it comes to data handling of private information, it would be one where it's not invaluable to have a refresher, because teachers have tremendous demands on them. Tremendous demands in our modern day educational system. And so to have a refresher as part of an annual course would not be too strenuous, and it definitely would be valuable.
Representative Blash?
Oh, Madam Chair, I was just going to ask if we were going to hear from the school districts or opponents
Yes.
or whatever. So.
Yes, they are on the list. All right, did we get through the bill or no?
Very close.
Okay.
Madam Chair, let me just for the sake of being complete here, I'll go quickly and ask questions. But back to subdivision 10, that simply states that there will be no sharing or transfer of the PII from a device unless it's sold as part of a merger. So that would obviously make sense. Subdivision 11 pertains to limitations on direct access to the device. We've talked about that a little bit already. Subdivision 12 deals with the return of the device and data deletion of whatever was on that. Subdivision 13 is sort of the catch-all understanding that there's a difference between the stuff that's preloaded onto the one-to-one device, or that is authorized by the school for use, and whatever stuff a student could get into on their own. So we're not going to be holding other third-party tech platforms that a student engages with at home necessarily to the same standards under this bill. Section 6 of the bill is about evidence, and that evidence or information obtained or collected in violation of the act would be inadmissible in proceedings, student disciplinary actions, or administrative hearings. That's kind of giving some teeth to this bill at the end of the day, that you have to take this seriously, and if you're going to collect student data as evidence, you have to make sure you're doing that properly. Section 7 is training, which we've already talked about, that annual training requirement. Section 8 are other penalties for violating the act, civil penalties up to including attorney's fees, again, to give this some teeth. And then the effective date. So we've finally made it all the way through the bill. Sorry it took a while, but happy to answer any questions.
And one question that I had a call from a reporter at the Minnesota Daily, I think. I don't know if he's still in the room. Anyway, he was wondering if this bill and Senator Kent's bill also apply to higher ed or just K-12. And I don't know if you guys, Representative Lucero.
Thank you, Madam Chair. The intent is not to have it directly apply to higher ed. Our focus on this bill is K through 12, but there will definitely be impacts in terms of transcripts, so it's sharing of information, transcripts, letters of recommendation, potentially awards, things that might be contained within systems in K through 12 that would be important information for colleges to know as part of that process.
Because the statutes here, and the bill basically says it applies to public schools, and so that could include higher education. It isn't, I don't think it's specified that it wouldn't apply to them.
So, Madam Chair,
Sir?
So line 2.10, the definition section is education institution, and we have references to which educational institutions that it is applying to, and I am very confident that higher ed is not part of that definition.
Would you agree with that, Steph? Okay.
And Madam Chair,
Representative
while-
Senator Kent.
while we're on the subject, I'll just clarify that it does specify K-12 in my bill as
I
well.
did see that in your bill, actually, yes. Okay. Any other member questions? And I really need to move on to the next bill because we're halfway done with our committee time here. Senator Kent, did you have a question first? You were acting. And ladies, I'm sorry, I know you came prepared. You kind of did a comparison, so let's save that for the end. And, but I want to get through Senator Kent's bill.
Madam Chair, if I could
so
just
much.
make one comment, and that is,
Sure.
I won't do a comparison, but if you, members should have a sheet that looks like this. It is a comparison, and I would just make one statement regarding Senate File 1980. It's a great bill, and I would say that when comparing the two bills, I would say that this is a good bill. Ours is just a little bit more comprehensive and touches a few other areas. And so having read the bill, there is really good language in here that I intend to incorporate into our amendment going forward. So.
Okay, thank you. Welcome, Senator Kent.
Thank you, Madam Chair. And in the interest of time and in the interest that many of us have seen this in the past, I'm going to try to top line it as quickly as possible, but happy to go over questions. Very quickly to sort of provide some overview and background for this bill, because as Representative Lucero pointed out, and to sort of compare and contrast based on what we've just been discussing, this bill does nothing in the one-to-one devices discussion. That is not a part of this scope at all of this bill. This focuses on the partners, online partners and vendors and that kind of thing, which I'll go through more details on the definitions. As a little bit of history on this one, this came from an early meeting of this particular body when it was first created, and we had a hearing and we went over current law, both federal and state, regarding student privacy. And after that hearing and a conversation with Senate Counsel Ms. Pontius, we talked about how do we update Minnesota statute, and I give her all the credit for really taking existing Minnesota law. We had looked at other states. California was the one that was most obvious, and identifying where we needed to be looking to go to really update these areas to protect Minnesota students. Basically, we're dealing with sort of 20th century laws addressing 21st century technologies. So this was a very thoughtfully and carefully constructed bill to find the gaps that exist in Minnesota law and to fill those gaps. So it is in a much narrower scope, on purpose, by design, again, that came out of this commission. It was introduced because of the work that went into doing that. It was introduced late in 2015. It went through the process in 2016. It went through all the committees and passed off the Senate floor with strong bipartisan support. The original version of this bill, Senator Limmer was a co-author, and I'm forgetting it had strong bipartisan co-author. On this one, you'll see that it's just me and Senator Dibble, but this one was also a little late, which is another story. So I did not run around and get enough signatures on it, but. I'm hoping Senator Limmer will be on it again. And Senator Newman, while you're at it. It passed out of the Senate. It passed off the floor in the House. And then, for reasons that still remain unclear to me, when the final bill came out of conference committee, it was not there, in spite of it having passed both bodies with strong I think it was a unanimous vote in the House when it was heard on the floor. This has, because it is focused, because it is tight in its mission, and we worked really hard with stakeholders from all sides, it has had broad support. The other thing I will say when talking about these issues, obviously there is no debate that we want to protect student data privacy. Period, full stop. Likewise, as we know, through so many facets of education, we are using technology, whether it's testing, whether it is, me putting lunch money in my kid's lunch account. School districts use the resources for scheduling, for communicating with parents. There are just so many different ways that technology touches our educational system. And so those areas need to be able to work, but we also need to be able to protect student data privacy. And so the goal throughout this, and that has been this process, is to find an approach that allows the systems to function while locking that down as well as possible. The one criticism that we've ever gotten on this bill is that there's this general sense that maybe it doesn't quite go far enough. And I'm always like, fine, show us. Let's come up with solutions. We want to make this as tight as possible. And then there's never a specific recommendation on how we would do that, but I remain open to that. And that, in fact, that was the reason the bill was a little late this time around, because I went back, because more and more states are adopting these same types of provisions. And as we are learning from everyone's experience, what can we do to make our Minnesota policy even better? And so in that process, here we are with the current version of the bill, and I will go through it, as I said, pretty quickly. A number of these things I don't think I need to reiterate, because Representative Lucero's bill obviously set the stage and a lot of the context. So I'm working off of Senate Council's summary just for brief purposes, but we can go through specific language as needed. Section 1 is definitions. Section 2 identifies, excuse me, and forgive me, I am a little under the weather, so voice and all that good stuff, and dehydrated. So prohibited activities include, as was discussed previously, targeted advertising, creation of student profiles, sale or unauthorized disclosure of information. In subdivision 3, the security procedures and practices are specified for an operator to implement and maintain. And this was Senator Limmer was integrally involved in this conversation regarding deleting students' protected information within a reasonable period of time or within 45 days. We spent a lot of time and did a lot of research around the country to sort of find that best standard. Subdivision 4, permissible disclosures, such as federal under state law, legitimate research purposes as specified to a local or state educational agency for school purposes. Subdivision 5, use of information by the operator. And so this says that the operator may use protected information to improve educational products, to demonstrate the effectiveness of their product or services, sharing aggregated information, using recommendation engines for specified purposes, and responding to student requests for information or feedback. And finally, it specifies certain activities that are not affected. So law enforcement agencies may obtain information as authorized by law or pursuant to a court order, using student information for adaptive learning or customized learning, excluding general web audiences. So for example, if Google is being used in an educational setting, that is one thing, but if a kid is at home on their computer and does a Google search on their own, on their parents' computer, we're not gonna regulate that. Let's see, general marketing, storage, interactive computer service, that sort of thing. So with that, that's an overview, and see, I think there was one other point I was going to make, but it's not coming to me right now, still a little fuzzy-headed, so
No worries.
thank you. Any questions?
Member questions on this bill? Senator Newman.
Thank you, Madam Chair. Senator Kent, when I went through the bill, and I may have missed this, but two things I didn't see that I expected to see is what happens to the information after the student is no longer a student. You've got a student in here defined as through 12th grade. What happens to the information after they're no longer a student? And the second thing that I didn't see is any type of a penalty for failure to comply, which is something I would have expected to see. So just your thoughts.
Senator Kent?
Thank you, Madam Chair, and Senator Newman. I believe, and Ms. Pontius, correct me if I am misspeaking here, but I believe that the deletion provision within, if the school requests deletion of the data, I think that is, should cover that. And then in penalties, you're right, we did not identify any penalties in here. I think the conversations that we've had about this, and namely in the Judiciary Committee, had to do with, contract enforcement, because these become breaches of contract at that point, because these would all be covered.
Ms. Pontius, I believe on 4.4, it addresses the deleting of a student's protected information within a reasonable period of time, but not, I guess it's not broad enough to delete all of that student's records, or if you want to address that issue?
Yeah, Madam Chair, yes, it's correct. It doesn't have the more explicit deletion requirements that are in Representative Lucero's bill. So.
Okay.
And it also doesn't have a remedy section.
Say that again, please.
Also does not have a remedy or enforcement section.
Right. And I would say, I would, be glad to specify that upon graduation, that the personally identifiable information should be deleted.
I had a question regarding the definition for protected information and how that would differ from personally identifiable information. I don't want to recreate a wheel here. We already have we kind of have that defined in statute. And I don't know if you know the answer to that, Senator Kent, or if you want staff to answer that.
I would like to, because Ms. Pontius so carefully crafted all this for very specific reasons, I would like to get her to respond to that.
All right. Ms. Pontius, if you're prepared to answer that.
Yeah, Madam Chair, I think the idea, and it may need some wordsmithing, is that it is basically personally identifiable, and it's certain types of information that are submitted to an online service that would be covered. So it's a little different in that the scope of the bill is a lot broader than what would normally be covered by the Data Practices Act. These are providers of services that are outside of that. They're not linked to an educational institution.
So, Madam Chair,
Senator Kent.
Ms. Pontius, correct me again if I'm wrong, but given the nature of the type of data that gets collected through a student's activity or through a school's activity with some of these information services, like the profiles, for example, that there's data that is gathered that then can create a profile. So this, to Ms. Pontius's point, recognizes that we're in a different area here than the previous law covered.
And never mind. Any other questions from members? All right, seeing none, thank you.
Madam Chair?
And, Representative Lucero.
Thank you, Madam Chair. Just not a question so much, but just a comment. One of the things that I think both of our bills actually lack is in Senate File 1980, it's on line 3.29, and require the service provider to implement, excuse me, and maintain reasonable security procedures and practices as provided in subdivision 3. In my bill, I shouldn't say my bill, in House File 1507, it's on lines 4.6, establish, implement, and maintained appropriate security measures consistent with department guidelines and current best practices. I have seen enough times where appropriate and reasonable are in the eyes of the beholder, and they just come up short. And I do not like the language in either one of these. And so I'm thinking back, what have we done here recently? And in two bills, I can't remember the two, I think it was the body cam legislation, and it might have been the automatic license plate reader legislation. We actually wanted to, excuse me, link, no, I'm sorry, it wasn't those two, it was the body cam, and then there was something with the deputy registrars that wanted to expand out or store information electronically, I think it was. So we wanted to have some standards in place. And so we actually hooked both of those scenarios to the FBI's information security policy.
Right.
And one of the things that I think it's Obviously, FBI connotates law enforcement context, but when it comes to technology systems, as I was mentioning up there, technology system is a technology system. Minimum password requirements, complexity of a password requirements, and the handling procedures are all the same no matter how that technology system is being used. So I think that that's a good language to take this, the language in the bills, to hook onto something that, number one, is not just reasonable and uses vague language, but hooks to something definitive. But then number two is going to be updated, because policies and standards can become stale if not updated. So we know that's a document that is applicable then to technology systems in this context. So I'm just putting it out there, food for thought, that was my idea of something to switch this language to hook it onto to the FBI's documents. So
Good point.
And Madam Chair, if I can just add a couple quick comments. To Representative Lucero's point, I have been and remain open to fine tuning this. Again, we continue to keep an eye on how things are working in other states as more and more states implement similar types of provisions. I'm not sure what we're thinking about as in terms of this commission and how, if we're just talking about this so that as we get ready for session and bills will be heard in committee, that then we're informed and can have these conversations. But to Representative Lucero's earlier point, as we know, when we start talking about some of these issues with our colleagues, they tend to put them all in one big bucket and go, one of the things that I think is an advantage with this approach in Senate File 1980 is that it is very contained. There are other issues. I mean, when we were talking about the one-to-one devices, there are a lot of hot button issues. And, I think we should all consider if the best idea is to try to, on the one hand, tackle something that's really relatively doable, without a lot of controversy, knowing that there are going to be sort of more challenging discussions on some other areas. I am open to that discussion as well. But my point has been on this one that this is something we can pretty easily do. This is relatively low-hanging fruit. Right now, we've got a door that's pretty wide open for our kids, and we can close it, if not 100%, almost. And so that's why I think it's important that the provision similar to what Representative Lucero has in his bill and then what's in Senate File 1980, we should be able to do that, I think, without too much effort. So I hope we can do that, and I appreciate the Commission's help and guidance in trying to get to that goal.
Thank you. Any other member comments or questions on this particular bill? Suggestions? Anyone? All right. Thank you. We will move to public testimony. Kevin McHenry is first, Assistant Commissioner, Minnesota Department of Education, and on deck is Todd Iverson with the College Board. And after that is Joel Verduin. And before we have the first testifier testify, I would like to introduce our new committee researcher. Maren Bartal, is that? Bartal is joining us. And so I'm going to give her the microphone to introduce herself and tell us a little bit about yourself, where you went to law school, all those good
Sure.
things.
Do I have this on mute?
It's on.
I just need to talk into it, huh? I am Maren Bartle. I went to the University of North Dakota School of Law. I'm originally from Chaska, Minnesota, so moved back to this area and am working on transferring my law license from North Dakota to Minnesota. So I am in the middle of that process, which is a joy. And so in my extra time, I am now the research assistant. So that's kind of the update on me.
Wonderful. Thank you.
Anything else?
Welcome.
Okay. Thank you.
All right. To our first testifier, Kevin.
Madam Chair, members, Kevin McHenry, Assistant Commissioner at the Department of Education. First and foremost, we do want to share that we do agree fundamentally with you as a committee and both authors, Senator Kent and Representative Lucero, that we want to do the best we can to protect student level data when we're dealing with individuals that are minors. We want to be extra cautious in that. So you taking a deep look into this and what the right steps forward, we applaud that effort. We look forward to being part of that conversation. I did want to share a few comments and just in reviewing where these bills are at right now as you are moving forward. I do want to encourage you all to really consider some of the work that is being moved forward from the education committees in the legislature as well, to make sure that as we are trying to implement the law with fidelity, that we are able to do that, to meet the requirements that you all are looking to move forward in the Data Practices Commission, and also the requirements out of that Education Committee. An example that has just passed last year that we are working to implement right now is a bill that would have us further disaggregate student level data by racial and ethnic groups. What that would do is we are asking for more information from all parents or everybody throughout the state of Minnesota. The data attached to each student will have new categories, additional categories. The more categories that you're adding on to student level data, it makes it more difficult to protect. I shouldn't say that. It makes it more difficult to make sure that we are able to provide the data in the manner to the public and to the legislature so it can be interpreted properly. An example is all student level data categories. Anything under 10 will be considered private data and will not show publicly. As we look at additional race and ethnic categories by school and by classroom, what we could see is more data being blocked through that. We're doing our best to protect that, but by further disaggregating data, we are asking for more data from parents right now. The other thing that we do want to clarify is that we do have a role with our data sharing agreements for educational research. And we want to make sure that as you are moving forward and you are considering that there are areas that have been moved, we enter into data sharing agreements. There are areas that the legislature would like us to enter into data sharing agreements that we want to make sure that we can comply with. An example I'll give to you is, I believe it was in front of your committee, Madam Chair, was around our MCA exams. There was a law passed where students that scored a specific score on our MCAs would be allowed to go to Minnesota State institutions and would not be required to pay for remedial coursework. We are able to do that through a data sharing agreement. And through that, students will then, they will have less to pay in tuition through that. So there are some good purposes that we want to make sure that we are protecting moving forward. I did want to raise 2 more points, one around this bill refers to the SIS vendors and Representative Lucero's bill. I do want you all to be thoughtful and cautious as you move forward with that. Districts are, and I know they will be up after me. They are working with their SIS vendors because they can provide a service at a cheaper cost that can help them deliver the data that they need to deliver. We do something very similar with our testing contract. We work with a vendor that can provide a service that at a cheaper cost than what we can provide. And if something is passed that would impact districts working with SIS vendors, that could increase the cost of doing business. I will leave that to districts to discuss. The other point, when you are working on opt-in language, we do have a concern of where that language may go. We are required to, for federal and accountability purposes, to report how our schools are performing. We want to make sure that we're still able to do that. We also want to make sure that under our report card, that as parents are looking at how our schools are performing, that they're able to get a complete picture. If there are some opt-in requirements of what goes in through an SIS provider, that could impact what data is available and actually how schools are performing. I'm not saying that's exactly what's going to happen, but I just want that to be a consideration as you all are looking forward as this legislation is passing or moving forward. A couple things I did want to raise that did come up earlier, just to make sure that there's proper information on the table. I think Representative Lucero has been very diligent and has always had an open door with us and has had us into committee quite a few times. But there's a difference of the data that we have as a department or that is shared as a department, and there's a difference between data sharing agreements. And so through our data marts and the data that is used for federal and state accountability purposes, we do have mechanisms in place to protect that data in terms of who at MDE has access, and that's quarterly updated where we supervisors are signed off of who has access to make sure that data is correct. And also that Minute is also responsible for protecting the security around that data. So that's in terms of what we're doing for our report card and our data. In terms of the data sharing agreements, I agree with what Representative Lucero had said and has raised some good points of what we could do to be stronger in terms of accountability with who we're sharing data with. We have done, Representative Lucero raised the issue of audits or trainings. We have visited sites after that hearing and based on feedback from Representative Lucero. It is something that we're not, being honest, we're not experts in specific data security. We would like to enhance what type of visits or audits or trainings we would do. That's something that we're looking at. How can we do that under our current structure? We have one individual who is our data compliance officer who is already working on trainings for districts, whether it's in person or through webinars. She has also done trainings for all of our state employees at MDE for data privacy and data practices as well. So that's something that we do take seriously. And then as you move forward with this bill, we do encourage you to continue working with all stakeholders involved, including the districts, including schools, including charter schools, to help you arrive at the best possible product. With that, thank you all very much for your time.
Thank you. Mr. McHenry, we had a discussion here about the training of school personnel in FERPA and whatever this new law ends up being. From the Department of Education's perspective, what are you all telling the schools right now that they need to be doing in regard to, at least for FERPA right now?
So Madam Chair, members, under FERPA, the FERPA training isn't annually required. It's not a training that is specifically required. It's something that I think that that can be encouraged for schools to do. We do, there is a requirement for update annually for districts to provide to parents of what data is being used. I think that we'd be supportive of new ways to provide trainings to make sure that they're thorough and fair for districts. I know that additional trainings can be a burden, but we'd be more than willing to continue to work with you on the best ways to provide trainings.
Thank you. Questions for this testifier? Thank you, Mr. McHenry.
Thank you.
All right, Todd Iverson, then Joel Verduin, and Ben Feist, were you going to testify again? What did he say? No? Okay. Oh, a few comments, okay. We have a handout here, okay?
Some background information, thank you.
Okay, perfect, thank you.
Madam Chair,
Go ahead, introduce
in the
yourself.
interest of time, my name is Todd Iverson with the College Board. Just as background, very quickly, we were founded in 1900. The College Board was created to expand access to higher education. Today, we're a mission-driven, nonprofit organization made up of over 6,000 of the world's leading colleges, schools, and other educational organizations. Through our programs, we try to open kids' futures. Madam Chair, I'm here today to ask you to very carefully consider and look at unintended consequences as you work through this process. I had the opportunity to sit down with Representative Lucero prior to this meeting and share some of the concerns that I'm going to express with you, and I look forward to working with you as you move through this process. The College Board is very concerned about the parental consent provision of House File 1507. The College Board has a deep respect for student privacy, and we are committed to protecting it. We are a signatory with more than 200 K-12 service providers and educational leaders of the Pledge to Safeguard Student Privacy, a public commitment for a responsible collection and use of student data. We do not sell student data. We license the use of data that we collect to eligible colleges and scholarship organizations under a tightly monitored contractual parameter. They must use the information for educational purposes, and we monitor their outreach by receiving the same material that the students do. We believe that House File 1507 could possibly create a provision requiring parental consent before a student chooses to be connected to scholarship and post-secondary institutions through the College Board's Student Search Service. Student Search connects students with information about educational institutions and financial aid opportunities from nearly 1,700 colleges, university, and scholarship programs and educational organizations. It is a voluntary program that a student can opt into when they take a College Board assessment, and they can opt out at any point. Through alliances with new scholarship providers, the College Board connects students to nearly $183 million in combined annual awards. Our scholarship partners include American Indian Graduate Center, the Asian Pacific Island American Scholarship Fund, Indigenous Education Incorporated, home of the Cobell Scholarship, the Hispanic Fund, Jack Kent Cook Foundation, and the United Negro College Fund. Additionally, students who take the PSAT NMSQT and who meet published entry requirements may enter the National Merit Scholarship Program, conducted by the National Merit Scholarship Program. These scholarships play a real meaningful role in helping students propel themselves to success at college and beyond. We are concerned that Minnesota would become the first state in the union to require a parental consent to participate in student search, which would affect students as they try to achieve their highest possible goals. At the College Board, we want to clear a path for students to college and more than $180 million in scholarship money, not put up barriers. Research has shown that parental consent requirements can especially be limiting for low-income students, the very students who need our help on the path to higher education. The impact of these provisions could be extensive. The College Board has no means to collect required consent since the students register for exams through the local school and district, not through the College Board directly. More importantly, we just want to work with you to make sure that students have every opportunity that they've earned. And I appreciate it, and at this time would stand for questions and in the interest of time.
Thank you. Representative Lucero?
Thank you, Madam Chair. And as was described, yeah, absolutely. We had a great conversation before this meeting, and some of the things that were described there, the College Board does great work and serves a great purpose. Excuse me. So part of the conversation we had was the question to emphasize, who owns the data? So first name, last name, street address, social security number, email address, phone number, et cetera, et cetera, et cetera. Whose data is that? Is it the individual's data, or does it belong to the school or somebody else? And if it's the individual's data, then the question is it right that there's permission before data is transferred? Then that led us into discussion that right now, nothing is transferred without permission. It's an opt-in, as I understand. But right now, the opt-in is for the student. So if it's students that are opting in, then the next question is, are students, do they have the capacity to fully understand what they're opting into? And is that legitimate? Now, I mentioned earlier, as a real estate agent at the state of Minnesota, minors cannot legally enter contracts. We recognize, we delineate 18 and above and below 18. And there's a whole host of things, of activities that we don't allow minors to engage in, getting their ears pierced, I mean, tons of stuff. So should one of those limitations be that students are not, they don't have the full capacity to consent to having information shared or transferred? But that got into another good point, was there's not a clear line on that. And so what we work together is the College Board's going to put together some language that will help myself, and I presume Senator Kent as well, to put together language, because we don't want to impede. They're doing a good service, but we need language to create an exception, because this is stuff that we want to ensure that people are fully aware of their aspirations in terms of the opportunities for higher education. So I look forward to receiving that the language as a consideration. So thank you, Madam Chair.
Any other questions for this testifier? Thank you, Mr. Iverson,
Thank
for
you.
being here. Joel Verduen, and then Ben Feist, and then after that, Tony Quillis. Good afternoon.
Good afternoon. Thank you, Madam Chair. My name is Joel Verdine, and I'm the Chief Technology Officer of the Anoka-Hennepin School District. Part of my job in the school district is to sign contracts and review contracts that deal with many of the software applications, technology purchases, testing platforms, a variety of things that we work with. So I work with, in conjunction with our legal counsel to make sure that those privacy policies are reviewed and that we've thoroughly looked through those and make sure that we agree with language and or that vendors use language that we give them in terms of what we are okay with. A point I would want to make, and I think, well, first I would say, and I would agree with Mr. McHenry, is that I think we all fundamentally agree that this is an important responsibility. How we conduct it and carry it out, we may have some differences on, but we agree that that's an important thing. Otherwise, I wouldn't be doing all of the work that I do with my contracts as I already do. One of the points that I want to emphasize, which with language perhaps needs to be clarified, is the provision of opt-in. Now, today's testimony before we began the open panel testimony indicated that vendors would be responsible for gathering opt-in agreements. With the definition of student information system on here, I probably have somewhere in the neighborhood of 15 to 25 student information systems that fit this definition, if not possibly more. I didn't really inventory all of them before I came in. The thought of 15 to 25 vendors calling my parents or conducting their own opt-in process would be a little bit daunting for me to think that that's going to be acceptable to our parents. If it's our responsibility as a school district, what I shared with Representative Lucero is that opt-in agreements are a really high standard. We also have parents with language barriers and have difficulties with a number of translations that we give them, and oftentimes we have to do a lot of outreach for non-returned kinds of things, even when it's things that aren't quite as far as opt-ins, where it's parents who ask questions about some of the materials that we give them, just to let them know that we're doing something in particular with their children. So it does create a lot of overhead within the school district. And so I think care needs to be given to determine when an opt-in is going to achieve the outcomes that it's going to for the work that's going to go in to do that. So at some point, hopefully there's more clarification on whose job it is to manage opt-ins. I think at this point I was of two different beliefs before this meeting, or one belief, but now I'm of two different beliefs on how we're expecting that to be carried out. One point I'd want to make sure that we don't have unintended consequences on is, so in our school district, one of the things that we've done is we've built our information systems over time. We have automated data flow between systems, and in some cases use middleware in between what might be two different vendors. The reason being is because we have so much change on a day-to-day basis. As human beings, we have a hard time reacting to that. So just to give you an idea with the number of, we have 38,000 students, and so on a daily basis, I think we deal with anywhere around a dozen people who've actually moved almost every day. And so that's information that needs to get updated, but sometimes it needs to be moved to multiple systems in order to be up to date. And if human beings are doing it, there tends to be a lot of difficulties, challenges, breakdowns in terms of how that works. So we've taken a position to automate a lot of our work. And what we do is every piece of the automation, we use the same contractual language. Each vendor is required to maintain the safety and the security of that data, no matter which one of those vendors it's going through. And what I want to make sure is not brought in as an unintended consequence is that isn't defined as sharing. If the opt-in agreements aren't there and that's defined as sharing, then I'll have difficulty. I'll have to have vendors make sure that they're selectively moving data through those systems. And so the impact on that can be very broad, meaning the possibility, if that's an unintended consequence, is that teachers may not receive full rosters of kids when they do things. Our lunch program may not receive all kids, and then when the student comes up to check out for lunch, then someone's manually going to have to intervene for that one kid, and we have lunch line issues. Library automation is another system that we've got that moves data through another system. So if those systems can't share as defined within this, if that's what the intent is, then that also would be an unintended consequence that will actually prevent some students from working with library checkout, or we have to find a manual way to do that, one of the two. And so I do want to make sure that if that wasn't what the intent is, that we just don't have language that causes that without knowing that that's how sometimes school districts conduct that work. couple of parts on, one of the other parts, and I think we heard a piece of this, but I want to reinforce it as well. There's a number of times when teachers are referenced within the bill. That is a very limiting term in terms of who can do things within the school district. And when it comes to, for example, we have a research, evaluation, and testing department that provides data to our schools and to our teachers about the performance on particular assessments. Those folks are not teachers. We want to make sure that they're not kind of left out because, again, just with the language, if it's left as teachers only, removing data from one system and sharing it with other people, other educators, then I want to make sure that those folks are not left out as another unintended consequence. The item with the laptops, a couple of points that I would point out. I had shared the locker example with Representative Lucero, and I would agree with him when he talks about that being a container. Things within the container have different restrictions. So our building principals, for example, they have greater access to those lockers and can do random searches, as an example, for drug searches. That's a common thing to happen in schools. However, when it comes to searching a student's stuff, then we have a much higher standard that we need to work with. And of course, the Fourth Amendment applies with that too, that we have to be very narrow in our search and it has to be justified in inception. I would generally think the same thing of devices as we're talking about them. And I do think in this bill, we should have a distinction between things that kids own and what a district owns. The section opens up with the idea that a device is anything that's even provided by the districts. And so I think the definition catches all of those three scenarios that were offered up in terms of the testimony here. So, and I'm not sure the rules would apply equally across those three scenarios. The one thing I would think that they would, and this is again where I would agree with Representative Lucero, when it comes to us accessing students' personal stuff, and we do this with our principals quite often, we have training on this, it's legal advice too, they have to be very specific. The search is essentially the same thing as the search of a student backpack. They have to have a reasonable suspicion to do that, and they have to be narrow in scope. They can't just open up a kid's phone and go looking through their contacts if contacts aren't specifically part of the issue. And so there are some things in place where that is supposed to take place. And if there's a concern that it's not, a parent can respond to that and actually hold the school accountable if a school does do that. There's a bit of things in here already that schools are required to do. I would have a concern about the not monitoring of students' website activity. We are not required to, but most school districts do accept federal E-rate funding from the FCC. The law that we have to agree to comply to is the Children's Internet Protection Act, which requires us to monitor student activity. And so those two things could end up being opposed to each other. If we're under state law required not to do it, but under federal law are asked to do it. In essence, it is an option. We don't have to accept E-rate funding for Anoka Hennepin. It's somewhere between $1.5 and $2 million. And so there's a significant financial thing to think about if we don't accept those. One point also that was brought up that I'd like to emphasize too, training. While there may be FERPA materials online, my belief is this bill is not FERPA, and so additional materials obviously would have to be provided. But when we ask our staff to conduct or be in training, oftentimes there is a time commitment that we have to give them too. So there is a real cost to it. So I don't want to make it sound or downplay it like it is there is an additional burden for school districts to do that. And again, my statement in that is not a value statement to say that it shouldn't be done. It is just to simply recognize that there are costs associated with that. We do our data privacy training through our employee onboarding. Just for some additional perspective, I can't guarantee what all school districts do, but we felt it was important enough to put into our employee onboarding process. And annually, we send out materials to our staff on their roles and responsibilities for safeguarding student data. We do tend to take that very seriously within our school district. I believe we do more in our district than I have in my past experiences, so I do support those ideas as well. Some of the problems problems that you have heard about, whether it was data breaches in some of the other communities, those have generally come about because of employee mishandling of things or mistakes in what they do. And so when we think about the comprehensive approach to data security, we have a lot of people in our district that need to understand what their responsibilities are and to try to act accordingly. So, and I think that is what I would agree with the overall bill. The opt-in piece of it, I don't think strengthens that position. It's a different intent, I believe, than it is to secure student data, because whether parents opt in or opt out, it may not be more secure. It just provides that for that individual. The one last piece I would say is the opt-in gives a vendor the ability to do things that I would never agree to in a contract anyway. So the opt-in is about whether or not the vendor can share that information with other parties. I generally would not accept a contract that has those provisions. I wouldn't accept a contract that markets to kids. And so overall, for me, I don't know how much of the opt-in piece would be an impact, because I wouldn't do those things anyway. So I would leave with that point for 1507, and on 1980, I don't have any specific points to share with you. The bill language is all language that I don't think causes any level of need for me to comment.
Thank you. It's really good feedback. We appreciate the on the street view from someone that's actually dealing with this day in and day out. Correct me if I'm wrong. I thought I heard you say that that your contracts that you have with the vendors are relatively similar in nature, contain much of the same language. Is that right?
I would agree that much of the same language that is put in here is language that I generally agree with as well, and I would require of our vendors.
Right.
We require no ownership of data, no access to the data for anything other than to provide us in the service we're asking for. There have been exceptions for, I'll give an example. One exception is that we're working with the University of Minnesota. They can use our de-identified data to support their research, but they have no access to personal data. And in general, we wouldn't even go that far with another vendor, because I don't have any need to support them in terms of whatever their goals are. But with the University of Minnesota and the research project, we did do that with fast assessment. But that's de-identified data. So I would agree with much of the provisions under the part that talks about what vendors should be agreeing to. Mm-hmm. That's generally what I would ask of them too. And
is your understanding that a few years ago, we had this Timber J bill that said if you're contracting with a government entity, if a private company is contracting with a government entity, that contractor is also subject to Chapter 13. Is that your understanding of the law?
I don't know. I don't know if I have given it enough thought to tell you that would be my understanding. We actually we put into our contractual language that we have a boilerplate language we've shared, and in that language we require them to follow Minnesota practices. When you get contracts from vendors, they may not always like that. They may not always agree to that, and their boilerplate language will not say that they agree to Minnesota state practices. We are certainly required to.
So do you still enter into a contract if someone refuses that?
I think we do. When there are a couple of times when we have done that where it's just risk versus reward. And in there, with legal advice, risk generally not being high, we've not gone to court. That generally is to protect us in terms of going to court. We've not gone to court with too many vendors over their practices. And so there are contracts that don't have that provision in it that we work with.
Wow.
So I have to be honest with it, with you.
I appreciate your honesty.
Sure.
Representative Flesh, you have any comments on that? Why do we have laws? I don't know.
Yeah, the headaches that this legislature has gone through to enforce the law as written when certain companies make decisions that they're not going to follow the law. And then we clarify the law for the Supreme Court to hear that there are still entities out there that are doing business with folks that are willingly dodging Minnesota law is of great concern. And I really hope that we do not exhaust very many more taxpayer dollars, reiterating again what we really meant. So, and I'm not sure if this is, necessarily relevant to what the testifier is saying, but I know that when you brought that up, you knew it would perk my ears up, and it did. And it brought back all these bad memories of 2015. It's like, why don't you give me a nice paper cut and pour some lemon juice on it? So thank you, Madam Chair.
Thank you. For any other questions for
Madam
this
Chair.
testifier? Representative Lucero.
Thank you. And so, yeah, we met, as the testifier said, I think it was a week ago, maybe 2 weeks ago. And in that meeting, there was obviously this testifier was there from Anoka Hennepin, and then it was the IT directors from, I think it was a medium-sized school and then a small school, if I remember correctly. And so it was well represented. And one of the things that really struck me in that meeting was Anoka Hennepin, obviously being the largest district, is they have a multitude of resources and the capabilities to be able to analyze template language. But the smaller districts may not. And one of the comments from the smaller IT directors in the smaller districts was, because they lack the resources of this larger districts, having some minimum requirements in terms of the contract would actually help them. It would help them negotiate with the vendors, because they, again, don't necessarily have the resources to be able to negotiate properly with these vendors. Being in the IT industry, I can tell you that the vendors do have their boilerplate language, that the vendors are operating with all school districts in all the states across the country. And so the vendors come to the negotiating table with their boilerplate, and it's up to the capabilities of each district to be able to scrutinize and understand what's happening and properly make modifications. So that's why I think it exemplifies the point that we need, as the state, to put some minimum requirements in, because not all school districts have the same capabilities. In terms of Minnesota being among the first, I think I've heard that a couple times here, moving forward with something like this. All countries in the world, the technology vendors are operating. And Europe, it's well known that Europe, each of them being their own countries, most of them have more stringent requirements that technology vendors have to abide by. And then you have China, and there's just a multitude of requirements. And we've seen there's a precedent of technology vendors bending over backwards and doing what's necessary to abide by those requirements. So even though we might be the first mover in this particular area, we need not be concerned that technology vendors aren't going to do business in Minnesota, because we've seen across the world they'll do what it takes in order to get to that target market. The opt-in processes. We do not want to, and the intent would not be to interfere with the operations. The operations, I think school lunches, there were other things that were mentioned, that will not be impeded by the language that we have. And if it's not clear in the present language in its current form, again, we're going to make that very clear in a future amendment. And then lastly, I'll just mention, when it comes to employee handling of the data, absolutely right. I think it was the South Washington School District that was an employee error. And I think it highlights the point that it's not just, and I said that at the beginning, it's not only people that are not authorized gaining access. It's people that are authorized to the data and how they're handling it. So it's very clear training needs to be in there as part of this, and we need not only worry about unauthorized access to the information. So thank you, Madam Chair.
Thank you. Thank you for your testimony.
Thank you.
Mr. Feist, if you could keep those comments super brief, because you were at the table before. Mr. Quillis, you're next. Ms. Kelleher, Grace Kelleher, and then Michelle Kenny.
Madam Chair, thank you. Again, Ben Feist from the ACLU. I just want to take a brief moment. Obviously, we're in support of House File 1507 and Senate File 1980 we're not fully opposed to. I mean, this has got a lot of good stuff in it. And I just want to clarify the reason that we're not as much behind this approach is that I sort of see this bill as accepting the fact that the horses are out of the barn. And we've already got our data out there, and now it's up to the third parties to not be allowed to do stuff with it. 1507 is meant to shut the barn door in the first place and not let that data out that isn't supposed to be out, that parents have not consented to being out. So that's a fundamental difference in the bill. And again, while I think there are a lot of things that are not mutually exclusive between the two bills. I think, in fact, you could move both of these forward in different parts. But the one thing, and Senator Kent is well aware, we've talked about this at length a year or two ago, that I have big trouble with the concept of recommendation engines being allowed under her bill. And what the recommendation engine is sort of a targeted marketing tool where robots behind the scenes aggregate all this data that's being inputted and then can kick something out. So when you have something from eBay or Amazon pop up on the Star Tribune website, it's because there was a recommendation engine in the background. I see that as a major loophole in the bill that I would like to see closed. We didn't get to agreeable language when this was up before, but if it moves forward, I think that is a really important loophole that could and should be addressed. But thank you.
Thank you.
Madam Chair.
Senator Kent.
Thank you. If I can just respond very quickly on the recommendation engines piece. It's not a fair analogy to talk about eBay and because that is marketing to sell something. And these recommendation engines are not saying, buy this book. It's saying, hey, you read this one Laura Ingalls Wilder book. Here's the next one in the series. It's about exposing students based on their interests and what they're already doing in the academic realm to other academic type applications. So I get the sensitivity, but the marketing is prohibited in the bill anyway. And so it's, so anyway, that's just and I know we have a testifier who's going to talk about some of this as well.
Thank you.
Can I respond really briefly?
Sure.
Sorry. And Senator, I respectfully disagree. I think the wording of the bill creates an exception where that company, if it's Apple that provided for free a copy of Hamlet, they could then target marketing a copy of Macbeth for cost to that child and to the family. And that's what that's about. And if that's not the case, I'd be happy to have some comfort language in there to not be the case.
We'll
Thank
let
you.
you two hash that out.
Keep working on it.
Mr. Qualis, and on deck, Grace Kelleher, after that, Michelle Kenny.
Madam Chair, members of the commission, my name is Tony Quillis. I have the honor of representing CompTIA, which is the Computing Technology Industry Association. I will be very brief. I know the time is long, and I'd like to almost cede my time to Ms. Kelleher because she's a good friend of mine, and I also know that I want you to hear from them, the School Boards Association. But Computing Technology Association is a national trade association. We have 100,000 members across North America. We do some government relations and advocacy, but we're known more for our professional certification programs. There's a smile to that side of the table over there because one of your members has been certified by our association. But I just want to let you know, you've seen here today, there are a number of stakeholders, whether it's industry, whether it's gone through parents, School Boards Association, Education Minnesota, the Department of Education, to go through, and these stakeholders have all come together with all their interests in 24 other states and have seemed to have solved this issue. Now, what variation it looks like, but the number one thing is to protect student data. I mean, to go through, I think as we all agree on that, you'll hear that up and down the table, is to make sure that student data is protected. And it's important to the industry also that to make sure that it is protected, but also allowing the flexibility for, you heard Anoka Hennepin, you've heard the Department of Education, unintended consequences, to allow this flexibility, to allow educational technology programs to exist. Representative Lucero has mentioned numerous times of how technology changes, not just yearly, but monthly, and how that goes through. To allow that flexibility, I think, is key to allow school boards and the Department of Education to meet state and federal mandates as they also keep changing. So I just wanted to point that out, but I wanted to thank Senator Kent, I wanted to thank you, Madam Chair, and I wanted to thank Representative Lucero. We've had some good constructive conversations right now with all the stakeholders. I think this is key that we're having these conversations. The industry wants to still be part of these conversations as we move forward. But again, to make sure that we protect student data, we make sure that flexibility is in there, but to make sure that we improve student education outcomes in the end. I think that's kind of the goal of all of it. So with that, Madam Chair, I want to thank you. I can be around any time for questions, but I want to make sure that you hear from Ms. Kelleher.
Any questions for this testifier? Thank you, Mr. Quillis. Ms. Kelleher and Ms. Kenny are together. And after that, Cass, Wendlandt, Rick Heller, and Rich Neumeister. Welcome to the committee.
Thank you, Madam Chairman and members. My name is Grace Kelleher, and I represent the Minnesota School Boards Association. We represent every school board member in the state of Minnesota, and I am very fortunate today to be joined by Michelle Kenny, who is an attorney and is counsel to the association. And we've spent considerable time going over this bill and trying to meld it with Chapter 13 and how it corresponds to what we've been doing. And just for the record, Madam Chair, we have a 41-page policy on protecting student data. This is the general piece that we send out to all our members. And it has been in effect since 1999, so clearly student data has been very important to us. It's not designated electronic versus paper. It is how you treat all student data. So on that backdrop, I want to also say Senator Kent's bill seems to put the onus on the vendor, which is preferable for school districts. Seems that they have requirements to provide those services to Minnesota students around the state. But with that, Senator Kent, I'm going to leave your bill and let Ms. Kenny talk about some of the just operating issues we have with the bill.
Welcome to the committee. Go ahead and introduce yourself to the group and for the tape.
Thank you, Madam Chair and members of the commission. My name is Michelle Kenny. I'm an attorney with Knutson, Flynn, and Deans in Mendota Heights. So what we thought we would do is kind of review the bill and highlight some of those areas that we think are important for the commission to provide further consideration to.
Which bill would you be?
I'm sorry, 1507.
Okay.
And I would echo most of the comments of Mr. Vudin, if I pronounced that correctly, from Anoka Hennepin. So I won't belabor those points. But just to add in with respect to the opt-in piece, it's not especially clear as to who would be responsible for obtaining that opt-in. We also think that there's the possibility it could be confusing for parents, as FERPA is an opt-out law, and under FERPA, the school districts provide an annual notice to their parents and students, setting forth directory information, also information that during 11th and 12th grade, information will be supplied to military recruiters and post-educational institutions. And what the annual notice provides is that if a parent or an eligible student who's over the age of 18 wishes to not have that information shared, that they can provide a notice to the school district that they opt out of those provisions. So there is some concern that we've got directory information and other of those pieces in the annual notice that talk about opt-out, but now we're providing something else to them that requires them to opt in. And that could be a little bit confusing among all of the papers and things that a parent needs to sign on an annual basis. Moving forward then to the training piece. As was noted, there is a real cost for the training. Even if you're able to do it by a webinar or electronically, there's the cost of people having to attend. And so you're still paying for the salaries for those teachers or other administrators to attend the training session. And MSBA estimates that on a statewide basis, one day of training costs about $2 million.
And so that begs the question then, well, what's being done now to train people? If this is a top priority for the school boards, student data privacy, what are you doing now to train the employees that you have?
Well, that's on a district by district basis. And so there is some training done, but it may not be to the extent necessarily that this bill is looking at.
So does the 41-pager there that you've got, Ms. Kelleher, does it address what your recommendation to the schools are in that regard?
It's not specific as to training. The policy that Ms. Kelleher referred to is the student protection and privacy of pupil records policy that tells the public how school districts are going to deal with private educational data and student records from both a state and federal law perspective.
Okay, thank you.
I would just note, too, that if we look at line 8.24, where it's talking about information in the opt-out, or the opt-in agreement, I'm sorry, it refers to when a student is age 18 or older, the rights of the parent or guardian under this subdivision terminate, and the eligible student assumes those rights. While that is true under FERPA, the federal law also provides that a parent of a dependent student still retains the right to access data, even though the student has turned 18. So just a note to keep in mind that is a provision under the federal law. Another piece that we noted was in line 8.27, it provides that an educational institution must review and respond to requests made under this subdivision within 5 days after receiving the request. And under the current data practices law in section 13.04, governmental entities are to comply to requests for data on individuals immediately or within 10 days of the request, excluding weekends and holidays. And it would be nice if both provisions were consistent. Going to line 7.5, I'm sorry, I skipped over there. It speaks to the opt-in agreement initially is laid out for the operator or the provider of the student information system and what they have to do in that respect. But starting or indicated at line 7.5 is that any person or entity that accesses or possesses any educational data or personally identifiable student information from an SIS provider is subject to the same restrictions and obligations under this section. I would suggest that could be read to also apply to the school district. And so if the school district was as limited in being able to provide information from the student information system, it would make it very difficult to respond to a data request, for example. There's no provision that allows for that. The only one that is provided in here reflects the educational institution can provide data needed to safeguard students' health or safety, which is specifically provided for in FERPA. It also does not address the other ways in which educational data can be shared. That would be either through parent consent, a court order, or disclosures under FERPA that do not require prior consent. So those types of disclosures would be missing. Also, looking at the definition of school employee, and the definition is pretty limited in that it is it's an individual employed and compensated by an educational institution who provides education-related services. There's a whole host of people in a school district that may need access to student data. And so, for example, if a school district authorizes a third party to come in and conduct an investigation for, say, an alleged violation of school rules. They might have their legal counsel come in and do that. And information contained in that student information system may be relevant or needed for the purposes of the investigation. This, an outside counsel would not necessarily fall within that, that school employee definition. Under FERPA, there is a provision that allows access and disclosure without prior consent to other school officials, and school districts are provided with the opportunity to designate who those other school officials are. And under the regulations, it defines other school officials to include teachers within the agency or institution who the agency or institution has determined to have a legitimate educational interest. So it would allow for a contractor, a consultant, a volunteer, or someone else who would have a legitimate educational interest in obtaining that data to have access. So we would just recommend that the commission consider looking at that. Another piece is the permanent deletion of data, and that's found at line 9.1. And it provides that an educational institution must permanently delete all educational data within 1 school year after a student graduates, withdraws, or is expelled. And so just some components with respect to that. If a student is expelled from school, they can be expelled for up to a 12-month period of time. Then they have a right to return to the school. And so there could be a problem with complying with the statute and deleting data and then having the student return. So you would have to go through the process of re-entering the data. The same holds true for a withdrawn student. We've seen students who withdraw from their residence school district, and maybe they attend school through open enrollment or a different program for a couple of years, decide they don't no longer like that program, then they return to the district. Well, as their resident district, they have a right to re-enrollment. And so there's the potential for that data having been lost during that period of time. Also, with respect to the graduate student, there could be some issues as well. But most importantly, we'd like to direct your attention to the school district records retention schedule, because school districts have a responsibility to retain records for certain periods of time under the law. Now, for example, school districts are required to retain the permanent record of students who receive special education students without a time limitation. Another example is that achievement and standardized test results are permanent. And so there would need to be a way for those pieces of information that fall within the records retention schedule to be retained for the period of time that is required by their schedule. So that concludes my comments with respect to the student information system piece. I have just a couple of comments on the one-to-one programs. Again, we would voice the same concerns with respect to the opt-in requirement versus an opt-out requirement. With respect to searching a student's computer, one thing that we could provide to you is that the MSBA has a policy on an internet, it's called the Internet Acceptable and Safety Policy. And specifically in that policy, it provides a few things. It provides that when the school district provides students access to computers and the internet, that the purpose that users are expected to use it for the purpose of further educational and personal goals consistent with the mission of the school district. It also provides that students have a limited expectation of privacy in their school computers. And so usually if we are doing a one-to-one laptop program and providing a notice to parents up front, this internet acceptable use policy is specifically referred to and provided to the families at that time. I think that the locker, the law regarding lockers and expectation of privacy is a good analogy for this. Placing a requirement that school districts have to obtain a warrant is a pretty high burden, and it seems to reduce the school district's ownership of the device and lean more towards in favor of the students' ownership. It looks more that way. But as indicated before, school employees are only required to have a reasonable suspicion to search a student's belongings if they are, especially if they are owned by the school district. So I think everything else has been addressed. So, and in light of the time, that would conclude my comments at this point.
I appreciate those, and I'm guessing maybe Representative Lucero wouldn't mind having a copy of some of your, if you have an outline of your issues.
Madam Chair, that's exactly what I was going to say. As a fantastic, constructive evaluation, and I look forward to a copy of those notes so that we can incorporate those into the bill and improve it the best we can.
I'd be happy to provide that to you.
Any other member questions? If not, thank you.
Thank you.
Next, Cass Wendland. Welcome to the commission. Please state your name for the record and go ahead with your testimony.
Hi, my name is Cass Wendland. I'm a student at Inver Hills Community College, and as you can probably tell from my massive laptop, I'm a massive nerd. So this is a topic that I have a great deal of passion with, and I guess as I had the opportunity to look through the bill. I had the opportunity to look through the bill last week, and I thought it was really both of the bills that are presented to the committee, and both of them are really good. And I appreciate that the legislature is taking an interest in ensuring that student data is more secure. I was disheartened to hear that it doesn't apply to college students, because I'm a college student and I have concerns with some of the ways that my college and some of the other colleges in the state are securing and sharing my data. So I would appreciate it if some time was spent looking into how can we protect and secure college student data too, because as a part of the courses that I take and the part of courses that a lot of college students take is we write stuff like political science essays or creative writing essays, or just stuff that we're students and we don't want our grades and our social security numbers and our essays and our academic work just being put into systems that are insecure or being made public for everyone else to see. A couple other things that I would like to throw out there is that I'm blanking on her name, but she asked, one of the representatives asked a wonderful question about how do we know that the providers of the one-to-one programs and that the software providers of the SIS programs are complying with these laws if they're passed and are acting in the best interest of the students and are securing their data properly. And it was brought up that audits would be one of the ways that we do this, and I highly think that's great. It's good that we audit the systems that we're using and make sure that they're in compliance with basic security guidelines and stuff. But if we really want to be serious about making sure that the systems that we use in general, that the computers that we use, that the phones that we use, that if we're really serious about that, we need to make sure that the systems and the software is free and open source. And this is me and my nerd passion coming out, is that if it's free and open source and that it's made public to students and it's made public to parents, the underlying software code behind those programs are made public to students and are made public to parents, who can then review and make sure that these systems are actually secure, that the software that's on the tablet that they're being handed actually matches with the software that was given to the school to see like, oh, maybe like my nightmare is I buy a computer and how do I know the guy from Best Buy didn't plug in and change the code on the computer? How do we know that the person in IT didn't make any changes to the underlying software? How do we know that the kid didn't accidentally download a virus or something? Having access to the source code just generally provides more security and makes everything better. And it also, the side benefits include giving students the opportunity to look at the underlying structures of the devices they use and provide them incentives to, get more involved with the software and computer community. Like if you're a kid and you're looking at this computer and you can say, and it's not constrained, if it's free and it's open source, it gives them an opportunity to, it makes it more like a blank notebook for them to write their own story in, as opposed to like a toy set where you can only make a couple of different action figures, is an analogy that I would say off the top of my head. But I really applaud the work that you guys are doing. I would ask that you take it very seriously, because what I'm always scared by and what I'm always hesitant to see is when these systems and these providers and these school districts and the colleges just say, just trust us, our systems are secure, just trust us, they've been audited. And I'm always like, I want to verify that. I want to be able to look at the source code and say, yes, I can see that this is secure. I want to know that there's communities of thousands of amateur and professional individuals who can review, who have access to this stuff and who are active on GitHub and can look at these public software and say, yeah, this is secure. Yeah, this is up to our community standards. And if they can make suggestions and make improvements to the software and say, hey, this is a way that you can improve, and then the vendors can improve the stuff that they're providing. So that's my brief spiel on why free and open source software is cool. So yeah, I'll be happy to answer any questions if you guys have any for me. But
Well, thank you for being here. And are you majoring in some sort of?
no, I am. People are always surprised to hear this, but I'm actually majoring in political science. So, which is why I'm.
Why would you do that?
I know, right? I guess to be completely honest, it's because I don't see enough nerds involved in politics. And
we
as a
can
master
point to
nerd,
those
We got one right over here.
well, when I say nerds, I mean computer nerds.
Yeah, no, I
And so
understand.
I was very happy to learn that there's someone who actually works in computer security as a legislator. It's like, that's great to see, and yeah. So that was actually my primary motivation, getting involved.
Well, at
in
least
politics.
you have a fallback plan that you are very astute in IT. And
Yeah.
if there are any employers in this room, I can tell you if they would rather have someone with an IT major or political science major, I can tell you which one that they would say. But no, thank you for being here. And some of what you said was a little bit over my head, but I'm sure Eric was following it quite closely. Senator Limmer, did you have a question?
I just wanted to know why my USB port doesn't send a signal to my printer.
Which, I mean,
Free advice right here.
I don't know if I can do tech support this far away and over, and I'm pretty sure that other people want to
Talk with the
testify
senator
too, but
afterwards. Any other questions?
try turning it off and on again is the first one.
That's usually the key.
Been there, done that.
All right. Thank you for your testimony. Greatly appreciate
I
it.
appreciate you guys taking the time to do this.
Okay, Mr. Heller and then Mr. Newmeister. Mr. Newmeister's going first.
Madam Chair, members of the commission, for the record, my name is Rich Newmeister. It's great to see a young person get involved, and I have no problem with political science and sociology. I was a double major, and I've had fun ever since, from many decades ago. The first thing off the bat, when you see two bills like this, and one of them was I opposed, not a lot publicly, but I remember interacting with Senator Kent on her bill. And I've talked a little bit with Representative Lucero. The bottom line is we have a section of law called Educational Data Dealing with Students, 13.32. So when I see a 17-pager and I see this other thing and I see new terms like protected student data and all that, I look at the basics of where we're going and what we're doing. We're just creating more confusion, more things on the books with new language, new concepts
that is basically there already in 1332. And people have already said some of those protections are in there. So my suggestion in all of this, as I said to some extent a little bit with Senator Kent and with Representative Lucero, what does the current law do now? Number one. Number two, if there are weaknesses in it or whatever, you can add to it. This is what has always been done in the decades. I mean, I can point out, and I spoke with a policymaker recently for a little bit of time, saying, you know, this section over here is already covered under here. This is over here. So one of the things that I would suggest is what are the 4, 5, 6, 7 things that are part of these bills that are important to be addressed, that there's question or whatever it may be that you think the law doesn't cover or should cover or it's not clear. Let's deal with that. I can't emphasize to put another 17 pages, which this bill is, another 7 or whatever, I think is ludicrous from my perspective, when I can already see a lot of the protections, and maybe some other folks can do that. The second thing is ask the school districts what they have to do already under current law to provide when I get my iPad. When the school districts in St. Paul got their iPads, I was livid from my perspective, and as you know, I am pretty calm generally. But the bottom line is they weren't giving a lot of notice. They weren't doing any things. I did some data requests. I did some blog posts on it, got picked up, raised some issues, you know, a little 2 cents of lobbying. There are other efforts too by other people. But there was more, you know, more meat to the bones. But still, I and others, and a good friend of mine, did some data requests of the St. Paul School District. Want to see the contract. What do you give to parents? Those kinds of things. Some of those items I've shared with some policymakers. To get a sense what the school board does now, currently under law, to tell people that when we give an iPad, what are you going to be collecting on the kid? What do I as a parent have to say, I want this, or whatever Apple is, like this is for Apple, for the St. Paul School District. What are they collecting? Can I get access to it? And the school district says, we're not going to get that for you. But under FERPA, you have, and under data practices, you have a right to find out what they're collecting. The term educational data is pretty broad. Now, that needs to be subsets. So the third and final point, what is the role of this commission? And I'm not pontificating on aspect or telling you what to do. It's your choice. But as someone who's been involved in helping create this thing a little bit, I was involved with other folks and all that. This is what I would like to suggest you do. One is take a look at all these things and make recommendations. And to say that if we are going to deal with the student iPads and all that, these are a number of things that should be included in a bill. Rather than sit up and down, vote particular points of the language of a bill, and then you vote on a bill and you send it out. But these are very important elements that are to be included in any other bill. 2, should we have all new language or deal with 1332 and, you know, do what needs to be done in there so that everyone knows that's where educational data is all about. And 3, and this goes to the overall arch of what the commission was created for, from my perspective, is to see the threads of things. And all this is, one is the security of data and what are the standards. Different agencies have different things. And so again, we're looking at, well, how secure is data, particularly on students? Well, maybe the commission might want to say, well, we're going to have developed these standards, and that any time that a state or local agency is going to be sharing private data, these are the standards that the vendors are going to have to deal with, or security, or audits should be part of it. You know, and again, I do many data requests. Some folks do audits, some don't. Some this, some that, you know, whatever. So those are just my points that I share. Don't recreate the wheel with all new language. See what's happening now. And at least now you have a staff person that can do some of the legwork. One of the things, if there's an interest upon yourselves to get a little bit more, what's going on there in school districts? Ask school boards to send you the data. What do they tell the parents and the kids about location data on my Apple computer? You know, do I have a right to have it turned off? Whatever. So, Madam Chair, members of the commission, that's my short comments.
Thank you. Appreciate it. Mr. Heller, introduce yourself for the tape, please.
You want to sign up? Thank you, Data Practice Committee. Thank you, Data Practice Committee. Anyhow, my name is Rick Keller, unofficial representative, twice exceptional and print disabled. I did send an electronic message out to the LCC, the Legislative Court Commission, as well as you members itself, the eight members here. I'd like to talk about, revisit the Senate File 1980, which just got put online before I came. It has to do with the word online. It has to do with this handout, which currently isn't online. I think it does a disservice in a timely way that if you have it at a meeting in paper form, that you have it electronically too for people to access it. The word online is mentioned under definitions. If you go to that bill and you search it, just like it has the word search engine, because it's searchable, meaning you can read out loud. There's a reason for that. As I expressed before, it's important that people get it in an alternate format. If electronic is not defined in the data practice, I again ask you to reconsider what the word electronic means as it relates to transparency. Because it needs, we need it updated, timely transparency even in this meeting. My suggestion regarding people to understand this complex situation is use principle of universal design. John Lesch's handout mentions that in 2010. That's part of the Heller handouts on March 3rd, which will move forward. What you do is you provide all the written words, but you provide the big picture, what we currently have and how these laws are going to change, visually how it's going to change what we have into what we're going to do. I don't know who has the capacity to do that, but they do it that way in a visual level. You want more public connectedness with the public that aren't bookworms, I suggest you might consider doing that. Another thing is the side-by-side comparison. Like I said, the sheet is not online, but when they do omnibus bills, they do have a side-by-side online in a written script. Something to consider in the future if you're going to do this, is so people can have one piece of paper in front of them. It's just a common practice up here that they do for omnibus bill. I don't know if this is omnibus or not, but that's a leadership's decision. I do like to make a suggestion on the state longitudinal data system. This is for the Minnesota Department of Education. I can bypass their consent to look at that data, that gross data. I think that's a relevant piece. If it's really secured and they ask for your consent that you're not going to use that data, I think that's something that's relevant as we move ahead about how secure is it. Just because I can take that URL and put it in a different window and go right to the data. I don't even have to give my consent. The other thing about testing. Such kids are tested for mastery on all these types of assessments regarding FERPA, data practice. Is there a test fail? Is there a percent that they have to pass on demonstrating what they know and can do? It's one thing to do it on paper, but do it in real time. The Department of Transportation for creating documents has a policy which is out of their scope for statute, but if somebody creates a document that's not fully accessible, they have them removed and get them retrained. So when they get another poke at it, at least they may need another repetition to get mastery. So it's something to consider when we look at what mastery is, and if you can repeat it. But if you can't repeat it, then you don't want to be practicing until you get another training, because it takes 2 repetitions for gifted, it takes 7 for average, just to demonstrate it. Something to think about. And then getting back to 508 refresh and content accessibility law, I have a handout here I'd like to provide you. And that handout has to do with my findings with 2 state agencies that are quasi, which meaning they're a school district and a state agency. And my findings said that their websites aren't fully accessible based on Minnesota Content Accessibility Law 16E.03 Subdivision 9, which requires state agencies. Legislature gets involved in that. So think about this when you think about the word electronic and it relates to other school districts. Isn't that bias that these state agencies have to make compliant for accessibility law? I mean, we're electronic, but when it comes to the .orgs, they don't have to. I think that's a serious thing you need to look at, because with ease and use and functionality, it integrates better too. If you got images, it takes a lot more process to convert it. And then not to mention, it's not compliant to ADA of 2008 regarding supplementary aid and services. Universal design principles, everyone will benefit. And I hope that the record that I handed out today, I'll be forwarding it to Greg, that will be posted in the same type of format. Also, the last set of documents, I went up and reviewed it. And the revisor correspondence from Ms. Timmons is not in there. So hopefully, even though the author wasn't in that, I didn't create it, but he can, because he's the data practice person, he can actually get the original that she created it in, which was my request as a PDF. And that goes back to 2015, I believe. So anyways, I appreciate that the minutes would reflect this, because I never got to see the minutes that were approved. I don't know what's said in those minutes, but I always like to look at those minutes. As you know, usually don't become public, only at this meeting, but not online. But if you put a watermark on it, said draft, at least I could have a look at it. I got here at 10 minutes to, and there wasn't any for me to ask for corrections to those minutes. I hope you appreciate allow me an opportunity to come back once I do my request, that if what I said at the last meeting will be reflected in those minutes. Thank you again for the opportunity to speak. I'm open to any questions if anyone is up to that.
Thank you, Mr. Heller. Are there any questions for this testifier? Okay. Thank you for your testimony. Members, thanks for hanging with us. Folks that are here in the audience, thanks for hanging with us. We're adjourned.